and welcome to Due Process the Interviews. This is Trevor Wadden. Before getting to today's interview, I wanted to provide a few updates related to the production of the first season of our show. Firstly, this feed, Due Process the Interviews, should be understood as a side podcast feed for our main show, which is simply called Due Process. Again, our first season will be a documentary-style podcast following the narrative of a case while also examining Canada's criminal justice system. Our first season will examine the BC case of Peter Beckett, who was charged with the 2010 murder of his wife and has undergone 2 jury trials and many twists and turns. We will be using a variety of sources and experts to examine numerous issues in our first season, including common conceptions of innocence and guilt, wrongful convictions, problematic evidence, juries, jailhouse informants, police interviews and interrogations, and much more. As it relates to Beckett, the Supreme Court of Canada has recently denied the Crown's appeal to revisit the Court of Appeal's decision to quash and overturn his conviction for murder, and the Crown has stated that they will not be proceeding with the third trial, meaning Beckett is now a free man. So, Beckett's fate is known, but our first season will look at the 10-plus year journey of how it came to be. And a foundational question that will be at the forefront of our journey is, what do we want our justice system to achieve? Not an easy question to answer, and certainly one capable of generating much debate, but it shall be one regularly asked in our first season. So, in terms of timeline, my goal is to have the first season released by November 2021. I'd like to release it sooner, but life is busy, and I'm essentially doing this on my own. I am aiming for quality and don't want to rush it. I'm simply giving myself a date to try to hold myself accountable here. If you are listening to this and have any experience in podcasting and think you can help, please reach out. My email is in the show notes, and I'm more than happy to receive feedback and advice. Moving on to today's interview, the topic again surrounds unreasonable delay and the landmark decision of R.V. Jordan, which set a new framework of 18 to 30 months for the Crown to complete a prosecution. I would encourage you to listen to my interviews with Eric Gottardi, QC, and Professor Christopher Sharon, episodes 11 and 12 respectively. This will give you a better understanding of the topics discussed in today's interview with Crown prosecutors Andrew Pilla and Levi Vandersteen. My conversation with Andrew and Levi primarily focuses on the remedy for unreasonable delay, a breach referred to as an 11B charter violation. As it currently stands, the only remedy available for when a violation is determined to have occurred is an automatic stay, which equates to the end of the prosecution. Many have raised concern with this automatic stay remedy, and Andrew and Levi are included in this group. Our conversation is at times academic, but it does focus on what I believe is an important legal and philosophical question, namely, what should the remedy be for failing to prosecute a case in a reasonable amount of time? We touched on a number of topics, including the Jordan framework generally, how an automatic stay came to be viewed as the only appropriate remedy in an 11B violation, why delay may not always immediately prejudice or harm the accused, and the proposed remedial framework, which balances the rights of the accused with the societal interest of proceeding with a trial on its merits. I very much enjoyed the conversation, and if you too enjoy it, please consider subscribing to this channel and leaving a review. To my surprise, people are listening, and I appreciate the support I've received so far. So I thank you for that. And without further delay, here are Andrew Pilla and Levi Vandersteen. Hello, and welcome to Due Process. This is Trevor Wadden. Today I'm speaking with lawyers Andrew Pilla and Levi Vandersteen about the right to be tried within a reasonable time and the charter remedy available for when this right is violated. Our discussion will focus on the landmark decision of R.V. Jordan and Andrew and Levi's 2019 article titled Recharting the Remedial Course for Section 11B Violations Post-Jordan. Andrew and Levi are both Crown attorneys in Ontario and have busy schedules, so we appreciate their time in joining us today. Andrew, Levi, welcome, and thanks again for coming on.
Yeah, you're most welcome. As we said, we're happy that somebody read our article.
Well, it was an excellent article, and we'll get into the specifics here, but we can start there. We'll jump in with some more background about why you guys felt this article was necessary. Why did you feel you needed to write this article?
We're happy to answer that. Just before I begin, though, I should indicate that these are our personal views only. They are not the views of the Ministry of the Attorney General for Ontario. It's important that I make that clear, but we're happy to answer your questions. Maybe I'll start because it was my desire to write this article very shortly after the Jordan case came out. And in part, it was because, for obvious reasons, it was a Supreme Court of Canada decision. There's no right of appeal to the Privy Council in Canada anymore. So the only way that you might get a change in the law is to write something that's academically scrutinized, and hopefully it'll have some persuasive effects on the Supreme Court. It's not like you can make any inroads at the trial court levels as it relates to this issue, it seemed to us. So we thought we would try something a little bit more academic and hopefully persuasive. And it was for that reason that I needed Levi's help.
And as Crown attorneys, are you seeing these Section 11B applications often or on a regular basis since Jordan?
What do you say, Levi?
Well, certainly on a regular basis. I don't personally see an uptick since Jordan, and we've received them on a regular basis, I think, probably since Ascot in 1990.
Okay, so in terms of how frequent they're popping up for you guys, it really hasn't changed much since Jordan?
Yeah, I don't think it stimulated an uptick in it. And some of the transitional cases were there, and they were especially prickly to deal with because they were kind of a double-barreled issue. I suppose there's a recency component to it. I mean, the COVID complications have tamped down all of that type of litigation, it seems. But prior to that, I would say, if anything, we saw a bit of a downturn. I think the general consensus amongst the criminal bar is that Jordan made the opportunity for a successful 11B application more diminished than it had been. And, I don't think that, we've seen any upticks in the litigation surrounding it. I think it's made it easier to get our heads around. And for that reason, they don't come out of anywhere or everywhere.
Yeah, I think that the majority in Jordan was successful in one of their stated goals in reforming the Section 11B framework and bringing a degree of objectivity and foreseeability to the prospects of success in a given Section 11B application. It's in part, I think, as a result of the imposition of the two ceilings in that framework, but it's given, I think, potential litigants a degree of foresight that didn't exist under the previous, more flexible framework as to what exactly the prospects are of success on a given application. And I think that has a host of benefits, and one of them is there are fewer applications simply thrown against the wall to see what might stick.
I mean, simply put, Moran was kind of hovering around 9 months, and that's kind of what the watermark for people was. And then when they heard 18 months, which is effectively double that, I think that it just took the wind out of the sails of would-be complainants in the 11B process.
Okay, and we'll get into discussing more just generally about the Jordan decision here, but just so our listeners are on the same page with respect to Section 11B of the Charter, which holds that any person charged with an offense has the right to be tried within a reasonable period of time. Just wondering if you guys could just tell us why this right to begin with is such an important right for an accused.
Well, I suppose it couldn't hurt to, defer to some of the cases on that. In Jordan itself, it says timely justice is one of the hallmarks of a free and democratic society. And then the case goes on to expand somewhat greatly. So there's all sorts of practical reasons that anybody beyond the criminal bar could easily contemplate. The longer a case takes, the more people's memories diminish. And diminished memories in terms of the quality of the evidence are only going to impair the trial process by way of the quality of evidence that's delivered. So, that's one highly important and practical aspect of it. The other is a little bit more esoteric, and that relates to, public confidence in the administration of justice. And, if there's no justice outcome that's attached in a temporal way to the events that, cause the case to be before the court, people they become detached from it and they can't understand why it takes so long. You have anything to add on that?
Yeah, well, there's an axiom in the jurisprudence which might be reductive somewhat, but that's that justice delayed is justice denied. And there's something to that in that memories deteriorate, people lose interest, witnesses may be lost, evidence may be lost, defendant is spending prolonged period of time either in custody awaiting their trial or on stringent bail conditions. And there's also something to, I would think, in the community at large, that confidence is lost in the administration of justice when it takes too long to bring someone to trial. So Section 11B is interesting from a legal rights perspective in that it triggers all of these different legal interests, both on the part of the defendant, but on the part of Canadian society as a whole.
And people think about this stuff, right? Like, it's funny. I was just telling Levi before we started, one of my harshest critics, my mother, just this morning said to me, she's like, and it was completely unrelated to the fact that we were going to be speaking to you. But she asked me about why is it that the George Floyd prosecution could be, done from start to finish within a year, since the prosecution surrounding the death of George Floyd. And, here we are in Canada. She said, how long does it take? And I said, well, usually, for a similar trial to that, it would take 2.5 years. She said, well, why is that? I don't know. It's just kind of the way things have unfolded.
Yeah, it definitely catches the public's eye. And as I mentioned to you off air, the first case we're looking at in our first season is Peter Beckett in British Columbia, and it's been ongoing for over 10 years now. So they can drag out for sure. And I want to talk now just about the lead up to Jordan. And I guess we could just focus on the era of Askov and Morin, which are decisions that were significant in the 11B jurisprudence. Can you give us a sense of how the court dealt with 11B applications in this era leading up to Jordan?
Yeah, so in the same vein as all charter litigation, or I suppose you could say much litigation generally, the approach to Section 11B can be divided into two inquiries. The first being whether a certain rule or charter right has been violated, and the second is what do you do about it if it has. And in the Section 11B context, those two questions are: has it taken an unreasonable amount of time to try the accused person? Secondly, if so, what ought the remedy be? The second of those two questions, the remedial question, that was decided before Askov, before Morin by the Supreme Court in 1987 in a case called Reiki and the Queen. It's not been revisited by the Supreme Court since that date, about 34 years ago. And so the second of those questions has been pretty terse in Canadian jurisprudence since the Charter, essentially, and that's that every violation results in a stay of the charges. The first of the two inquiries, as to whether the Section 11B violation has occurred, that legal rights analysis has had a more storied past. The previous test was devised by the Supreme Court predominantly in a case called the Queen of Moran in 1992, but it was developed case before that called Askov, and then subsequently another major case called Godin. But the Morin test is referred to as was a flexible and inclusive approach where the application judge would balance several factors in the determination of whether the delay in a given case was reasonable, including the length of the delay from the charge to trial, waiver of any time periods by the defendant, the reasons for the delay, any prejudice to the accused, the significance of the charge. They were all sort of thrown into this chicken soup test pot of relevance. And to be more precise, the Supreme Court, I think, in Jordan sought to excise some of those considerations from the Section 11 legal rights analysis.
Just to follow up on that, Levi, this flexible Morin approach, my understanding was it was criticized because it was kind of inconsistent. Why did this approach draw some criticism, this flexibility?
Absolutely, and it was criticized broadly by academics, by jurists, and ultimately by the Supreme Court majority in Jordan. The criticisms they levied towards the previous test are quite serious for jurisprudential language. They called it unpredictable, highly subjective, unduly complex, and said that the Morin test ultimately failed to achieve future compliance with consistent standards. And I think, at least in my view, a lot of those criticisms were justified, and sort of one of the arguments that we advance in our paper that's not necessarily touched on by the majority in Jordan is that all of those criticisms, in a way, can be seen to flow from this over-inclusion of different factors in legal rights analysis, which may cause certain analytic and doctrinal problems and cause practical problems for the administration of justice in Canada as a whole.
Yeah, it was kind of weird to see them do what we've characterized as interest balancing at the front end to determine whether the right was breached, as distinct from what we analyze in our paper and would suggest takes place at the back end in every other type of charter contemplation. I mean, it's in other areas of the charter, to figure out whether somebody was given their rights to counsel or whether their right to search be secure from unreasonable search and seizure, has been breached. In other words, somebody searches your house without a search warrant. I mean, those are easy determinations to make. Whereas in the Morin era, all these interest balancing factors were considered as to whether or not the breach itself had taken place. I guess the question becomes whether or not, when you look at how the case law evolved from Mills into Rahe, and Mills left the door open to the notion of not always a stay being the outcome, to once you see what happens in Rahe, where a stay is the automatic outcome, then you wonder whether the court sort of stepped back and said, wow, we got to inject some interest balancing here, like the other areas of the charter litigation, but instead it ends up front loaded rather than at the back end.
Okay. And under the Morin and Askov approach, how was prejudice treated? Was that on the burden was on the accused to show that they had been prejudiced in some way?
Yes. It was it's the accused's onus to demonstrate that, the right was breached. And in that, prejudice was a big factor. It's interesting, right, in Jordan, I mean, one of the criticisms is leveled, though, was secondly, as the parties point out, says the court in Jordan, treatment of prejudice has become one of the most fraught areas in the Section 11B jurisprudence. It's confusing, hard to prove, and highly subjective. And then there's a lot more that follows by way of criticism thereafter. So, yes.
And you've mentioned Rahe and the automatic stay, which we'll discuss here in a few moments. But what was the rationale in Rahe for why an automatic stay is warranted in an 11B violation?
Rahe's one of those cases that you saw a lot more often in the 80s, where there are several concurring and dissenting opinions. But even once you put together, I think it's the three sort of concurring opinions which ultimately form the majority decision in that case, the rationale is relatively sparse. It essentially comes down to the idea that if you have a right to have a trial within an unreasonable time, then having a trial after that time, it would only cause more delay.
Yeah, in fact, they say after the passage of an unreasonable period of time, no trial, not even the fairest possible trial, is permissible. So it can't sort of be reverse engineered into a fair trial, I guess, thereafter.
It's remarkable. So much has turned on it in the past 34 years. It's remarkable when you really get down to the nub, what logical basis entirety of this apparatus is really come from. And that is really it in a nutshell.
In your article, I think you refer to it, the automatic stay, as the ultimate remedy. Why is it the ultimate remedy?
Well, a stay is not a remedy that is particular to Section 11B violations. It's a remedy which is available for a host of different charter violations. It is often referred to in very stark terms as the most drastic form of charter remedy, a remedy of last resort. And the reason for that is it puts an end to a given prosecution. It first and foremost deprives Canadian society as a whole of a trial of their interest in a trial on its merits, but also deprives the defendant of their interest in an acquittal on the merits if the presumption of innocence ought to persist. It's an end to the litigation.
I guess a happier way to put it is that it's a windfall, and I guess some of the criticism that's leveled at it is that it's an unjustified windfall in some circumstances, or it can be seen as such by the public.
Yeah, and it's really remarkable the manner in which jurisprudentially a stay is treated in every context other than that of Section 11B. There's been quite a nuanced framework, remedial framework developed for other alleged charter breaches, commonly called the Babos framework, which has been developed and tweaked subsequently. And the test that's developed or been developed for whether a stay ought to follow is a very, very stringent one. It's available only in the clearest of cases. And we look at, setting aside the Section 11B context, some of the cases in which a stay has not been appropriate because it does represent such a drastic remedy. They include cases of quote-unquote reprehensible state conduct, cases where the Crown withholds substantial evidence which supports an alleged murderer's alibi, cast doubt on the credibility of Crown witnesses. Babos itself, two officers colluded about firearms evidence, and then the Crown threatened to lay additional charges if the defendant in that case didn't plead guilty, and a stay didn't follow in those other cases of reprehensible state conduct. And the reason for that is, as Andrew says, because it can represent a windfall even in instances where the state has acted negligently or in bad faith.
Which is, it makes it hard for not just the general public, but even people, immersed in the law, the criminal law, to get their head around the idea that you can see that type of state conduct and then, for very explainable reasons, and this is in our hypothetical in the article, we try and articulate, a hypothetical can really, push people's limits of understanding, which is that, you creep over a case with limited amounts of prejudice or no apparent prejudice, or in fact, maybe even some benefits to the person accused of the crime. And ultimately they creep over the, 18-month or the 30-month threshold by a day. And, it doesn't matter if it's a day, a week, a month, a year, once that breach has happened, the stay flows automatically. And in Ontario, in Toronto, we just saw that fairly recently. Now, it was a summary conviction appeal case, so it was an appellate court sitting in relation to the summary conviction appeal court, and they were dealing with an 18-month time frame. But the appellate court recalculated the delay, but came up with 18 months and 2 days and stayed it. And it sounds rather brutal, but that's the way the law is, and it shouldn't really be a surprise to anybody that will be the ultimate outcome.
And that's why we call it the automatic stay rule. Shorthand that we developed for it is that after the Jordan framework is applied and the calculus is conducted, the remaining delay is dispositive of both questions, as I put it at the outset of the article. What is there a legal rights violation, and what do we do about it? The second question is not asked in the Section 11B context. It stands, and so a stay, this most drastic remedy, automatically and inexorably flows from the finding of a violation of Section 11B.
This automatic stay, are there any other charter rights that would automatically generate this remedy?
I thought about that prior to doing this, and I couldn't conjure any. I don't know if you did, Levi. I guess my answer would be no. I mean, we see exclusion of evidence kind of more readily, but it still takes place in the wake of the grant interest balancing that takes place. I'm not aware of any, and I couldn't find any, having looked.
No. I mean, the two-step paradigm of is there a breach, what do we do about it is ubiquitous. It's applied in seemingly every other legal rights context under the charter, and we've been focusing sort of on individual charter breaches, but it's ubiquitous even when you go beyond that scope to, for example, when there's an allegation that a piece of legislation violates the charter, we apply the Section 1 Oaks test, which is perhaps the cardinal balancing test, and is the second in that two-stage paradigm. You can conceptualize a lot of litigation, including the criminal justice system, is sort of fitting into that two-step question of, has a rule been broken? And if so, what do we do about it, right? In the criminal context, can we prove an offense beyond a reasonable doubt? And if so, what do we do about it? That's called sentencing. It really is ubiquitous within the administration of justice as a whole, and Section 11B as it currently stands is a bit of a unicorn in that regard.
Would that be the interest balancing you're talking about then? When another charter right is violated, the court, they find that there is a violation, they then look at the different interests.
Exactly.
Yes, that's precisely what an interest balancing remedial framework would be. Interest balancing is a term that denotes sort of balancing countervailing interests against one another, and in the legal determination in the charter rights context, it generally takes the place of balancing defendant's interest in a particular remedy against society's countervailing interest in another outcome, generally a trial on its merits.
Is this automatic stay then contrary to even the charter in itself in Section 24(1), where it says that a court can provide a remedy that the court considers appropriate and just?
Well, it's fascinating. You look at Section 24(1) jurisprudence outside of the Section 11B context, because, as we say, it's terse to non-existent in the Section 11B context, but you cannot find more capacious language, I would argue, in another context. The jurisprudence is replete with remedial decisions about how Section 24(1) prescribes the widest possible discretion to impose any remedy which is fit in the circumstances, setting aside Section 11B.
Yeah, Trevor, with that question, you stole my one piece of potential intellectual thunder in this discussion, because when I was thinking about it only yesterday, I scribbled down the following thought, which is that, and we winnowed it down a little bit in discussing it yesterday, some more, Levi and I, but if Rahe were a piece of legislation prescribing the automatic stay, you wonder whether it could survive charter scrutiny. And what, if a piece of legislation that said that, you shall stay a case for creeping over an 18-month or a 30-month threshold were analyzed in the light of Section 24(1), which starts with the word anyone whose rights or freedoms and ends with to obtain such remedy as the court considers appropriate and just in the circumstances, you'd have to wonder whether it would be considered overbroad. Because, when you start with the word anyone, that doesn't mean everyone. It means anyone, which suggests that it's an individual right, not a right to be doled out across the board. And if that right, as it's been interpreted, is an automatic stay, well, is that always appropriate and just in the circumstances? So arguably, to prescribe that, you're fettering an individual court's jurisdiction to come up with a remedy that's otherwise.
Under Jordan, then, do you think discretion of the court has been kind of removed because of this automatic stay, but also the framework that Jordan introduced?
I don't know that it's any different in terms of the practical outcome. One other thing that we talk about in our paper is this notion of, remedial deterrence. And what of course you see is that very creatively courts adapt in a way that they start to find other ways to ensure that perhaps, what's appropriate and just in the circumstances actually takes place. And, we cited that case earlier, which is Hussein out of our summary conviction appeal court here in Toronto. That was recent, but a couple other recent cases at the other end of that are actually cited in Hussein might illustrate this. And without going into the facts, the decision of our Court of Appeal in a case called Paul's is interesting only because it's just, they conclude that there was a net delay of 17 months, 29 and a half days, and then declined, obviously, to find the breach and to stay it. And, that results in an appeal up to the Supreme Court, and Justice Moldaver presiding, or at least writing the decision. It's called Yusuf. So Pauls and Yusuf were co-accused, but it makes its way out to the Supreme Court under the name Yusuf 2021, fairly recently. And really what the court ultimately does is uphold the Ontario Court of Appeal, but declines to answer some of these more prickly issues that not so much it relates to what I would suggest is these remedial deterrence issues, but some of the other stuff that attaches to 11B litigation that's been bubbling along since Jordan 5 years ago. So I guess the answer, going back to your question, is the discretion removed? Maybe no more, no less than it had been. It's just dealt with differently.
And your article, and correct me if I'm not fairly representing your article here, but I took away a suggestion that maybe judges are unhappy with the automatic stay rule or the Jordan framework.
No, sorry, not with the Jordan framework, but it is recognized by the majority in Jordan that trial judges are often dissatisfied with applying the framework retroactively, and I'm paraphrasing here, but with only one remedial tool at their disposal, which is significant. I think that there is, as you take the Section 11B framework as a whole, including both the legal rights and remedial question as it stands now, there is a lack of at least explicit judicial discretion to address certain factors which Canadians may rightly see as relevant to the Section 11B analysis. We talked at the top of the interview about how certain factors have been removed from the Moran framework in Jordan. Those factors, we conceptualize them as threefold, being the seriousness of the delay, so how far over the given ceiling the delay persists and why it went over the ceiling, setting aside defense waiver and defense delay in exceptional circumstances. There's no difference in the Jordan framework between going 1 day over the ceiling and going 2 years over the ceiling. Both cases are automatically stayed, and there's no difference if it's state conduct that causes the overage. There's no difference between, for example, investigative steps occurring right before trial, which causes it to be adjourned, and bad faith state conduct or endemic institutional under-resourcing. So sort of the seriousness of the breach itself has been removed from the Moran framework. As we discussed, prejudice to the defendant or the applicant has been removed from the framework, which used to form a very large, though confounding portion of the Moran framework. And the third factor that's been removed in Jordan is the societal interest in a trial on its merits. That's often represented by the seriousness of the charge. Society conceptually has a greater interest in a trial on its merits when someone's charged with first-degree murder or a terrorism offense than they do with shoplifting from the corner store. So under the Jordan framework, when you take Jordan in conjunction with Reiki, there's no distinction made, setting aside whether the 18 or 30 month ceiling applies, there's no distinction made between serious and less serious offenses. And so the trial judge's discretion to address those three legal interests has really been removed in Jordan from the legal rights analysis, which we argue and I believe is correct, that those ought not to be factors under the actual legal rights analysis itself, but they do need to be factors, I would argue, under the remedial analysis. And the second question of what do we do about it? When it has taken too long, what's the remedy that ought to follow? And so currently there's no remedial question, so judges don't have any discretion to address those factors under the remedial analysis, and they've been taken out of the stage one analysis under Jordan. I think what Andrew's getting at is there is this concern that judges do what's right and just in the circumstances, and there's a concern that if you don't prescribe them under a given framework the ability to do that they may have to do that on an ad hoc or implicit basis instead.
Is that suggesting then that they might get creative in their arithmetic under the Jordan framework?
And that's recognized as well by the Jordan majority. It's been recognized by the standing Senate committee on this issue post-Jordan. It's been recognized by academics such as Professor Sharon, who wrote another paper on a similar issue. Yes, it happens. Because the most drastic remedy in the legal rights charter context flows inexorably from the finding of the Section 11B breach, there's a real question as to whether judges ought to be blind to whether they're being asked to stay a first-degree murder charge or something less than that. And if you don't prescribe them with the ability to do that explicitly, there's a concern that they may find a way to arrive at the appropriate outcome by bending the framework itself.
So Jordan was meant, as the majority says, to try to cure a culture of complacency. So what do you guys think of the argument that to really get this cure, to help with this complacency, we need to have that automatic stay, and that's a key component of it? Do you buy that argument? Would you still think we need to reconsider the automatic stay?
I don't know that we need such a nuclear option necessarily to get people to move in the right direction. I think everybody involved in the criminal justice system really, really works hard to ensure that both the individual rights of those accused of crimes and society's views of the administration of justice are both sort of assiduously safeguarded. I just don't think you need that necessarily to motivate people. And, when you contemplate the alternative, which is this older Moran regime, I was saying to Levi in preparation for this, one thing that can't be overlooked is that under the Moran regime, there was always the fear of the unknown, because you actually never knew where the number was going to land. So with that sort of unknown deadline, you just worked to ensure that everything happened as soon as possible. The perhaps unintended outcome of these hard cap Jordan timelines is that, in many respects, 18 months and 30 months is a relatively long time to get a prosecution done. I mentioned earlier, the prosecution involving George Floyd and how people look at that and how timely it took place and compare it to the notion of 30 months. It's more than a year difference. And so what happens potentially is that, in fact, you might end up with this culture of complacency necessarily creeping in, if only because the delay will expand to fill the available space. And that wasn't necessarily the case under the old regime. So I don't know that a stay as an outcome is necessarily going to motivate things under one regime or the other. I mean, it's certainly an important factor. But, I suppose the point I'm trying to make is that from the perspective of complacency, arguably each regime has its own available criticisms.
And I don't think anyone's arguing that there aren't certain cases that ought to be stayed for unreasonable delay. The question is whether that ought to occur automatically or whether there ought to be some remedial framework devised in order to make that determination, essentially whether a stay ought to follow in every single case. And also, when we're going back to what the rationale is, whether an automatic stay is necessary to combat the culture of complacency, it's important to note that the rationale for the automatic stay rule is not derived from Jordan. It doesn't derive from the Moran framework. In fact, it precedes both of those cases because it's from the 1987 decision, Rahe and the Queen, and that was not the rationale in that case. I think one could conceptualize a few different rationales for the automatic stay rule, which may persist, but none of them are explicit. None of them are jurisprudentially derived. And so I think that there's an argument that if that is required to combat the culture of complacency, then perhaps that ought to be an explicit case.
So the main complaint then with the automatic stay from your perspective, that there's just no ability to differentiate between the case that goes over by 1 day versus the case that is, 45 months over the framework.
Yeah, it could be an analysis of how much it's gone over. I'm not sure that shocks, I think, the community more than it does the people within the smaller subset of the criminal justice community. It's other elements of that. We talked about prejudice earlier. There's a line that was cited in Moran and other cases prior to Jordan, and it focused on the topic of prejudice. And I'm going to read it because it's compelling. It says, "An accused is often not interested in exercising the right bestowed on him by Section 11B. His interest lies in having the right infringed by the prosecution so that he can escape a trial on the merits. This view may seem harsh, but experience supports its validity." That comes from Justice Dubin. It was cited in Moran, and it's been cited in other cases. This is the Supreme Court turning its mind to this. So at the Supreme Court level, we acknowledge that there's these potential benefits that can flow. So we get this sort of perverse charter jockeying, charter litigation, even at the set date stage. And what ends up happening is we spend more time talking about delay than we do acting on trying to avoid it. And so you get these sort of unfortunate outcomes that attach to perhaps the hope of securing a stay. You might get somebody in the face of a very strong case to start to litigate and design their litigation surrounding trying to create and force a stay because they know there's no hope in having the case tried on its merits. So that's not in really anybody's interest, except perhaps the accused person, as I just cited. And so we go back to the concepts of the windfall and these other things. In our paper, we cite this hypothetical, and there was we alluded to, a person that becomes a YouTube sensation as a result of the charges. Perhaps, they're benefiting greatly from the mere fact of having been charged. So they're not under that exquisite agony. We wrote that paper before a case that got some national attention that was here in Toronto, and I think the case was often characterized as the chairgirl case. But, that we saw that person, certainly, her criminal trial process seemed to only expand her public profile. There's all sorts of outcomes in these types of prosecutions that aren't as straightforward in terms of, the traditional trajectory that people would attach to it.
And the chairgirl, this is a lady that threw the chair off her balcony in Toronto.
Yeah, and as I recall, there was a lot of notoriety surrounding that prosecution. And as I understand it, she continues to sort of benefit from the profile that she achieved as a result of it. So.
Yeah, the reality is the legal interests of the defendant and of society vary on a case-by-case basis. And as our regime currently stands, the framework is largely purposefully ignorant of those case-by-case variations, and that can have real ramifications for defendants, but also for Canadian society as a whole in terms of confidence in the administration of justice. I mean, one can imagine the chairgirl's case being stayed because it took 18 months and 1 day, and what kind of reaction the Canadian public might have to that. And the reason that the Canadian public would have that reaction to the case being stayed is because these factors are plainly relevant. I mean, prejudice suffered by the accused person, the reason why it took 18 months and 1 day, the fact that it took 18 months and 1 day and not 5 years. Canadians look at these things and think that they're relevant to whether the prosecution ought to be stayed, because they are, but they have no place currently in our Section 11B framework, and we contend that the solution to that is the creation of a remedial framework.
And we'll get into talking about your remedial framework here in one moment, but I just want to ask first, as your article addresses this, is there anything the government can do to prevent a court from applying an automatic stay?
I suppose the obvious answer is they could legislate. They could prescribe, I think it would have to be a little bit larger than that, but they could prescribe how long a case should take to get completed, and it would have to be subjected to charter scrutiny. And I suppose that would be in the light of all the historical jurisprudence. So it's an interesting question. Some of the criticism that was leveled in the wake of Jordan was that it veered into elements of either judicial activism, I think, was attached to it, or judicial legislation. I mean, obviously, judges interpret the law, and in so doing, in our common law system, they create it. But I suppose if that is the criticism that's leveled against it, then Parliament can weigh in and also come up with its own legislation as to, the duration that a trial ought to take, and then it'll be analyzed in the light of Section 11B, and they can prescribe the remedies, and they too will be analyzed in the light of Section 11B and Section 24. So that can take place. I don't have any special insight into this whatsoever, but I've certainly never heard any rumblings in the force field that Parliament seems to be contemplating that. I suppose in the wake of Jordan, there was some talk of it, but nothing seems to have ever come anywhere close to getting off the ground.
To me, there are two separate questions. It would be one thing whether Parliament could legislate a different Jordan deadline, essentially whether Parliament could legislate a 36 months, whether that would be charter compliant. And that might be vulnerable to charter scrutiny more than attempting to legislate a remedial framework. Because the jurisprudence is so terse on the remedial question, it's not clear from it whether, it's clear that Canadians have a charter right to a trial within a reasonable time. It's not clear, at least to me, that Canadians have a charter right to a stay when a case takes too long. And that's because the only two cases in which the Supreme Court dealt with this, and there are actually two, one is Rahe. We've gone through sort of the rationale, or the singular rationale in Rahe, but there's also a case before that called the Queen and Mills from 1986, which is quite at odds with Rahe, which seems to suggest that there are other available remedies for Section 11B violations, and it's in the wake of Rahe, it's never returned to favor. But that really is it from the Supreme Court on this question. And so
that's not quite it, I suppose, is our argument, right? There is footnote number one.
So
right? We know in Jordan, the very first footnote says, "We were not invited to revisit the question of remedy. Accordingly, we refrained from doing so." And that footnote followed on this passage, which is, "This after-the-fact review of past delay is understandably frustrating for trial judges who only have one remedial tool at their disposal, a stay of proceedings." It is therefore unsurprising that courts have occasionally strained in applying the Moran framework to avoid a stay. So I guess the bottom line is that maybe just flowing from what Levi just said about Mills is they started out by saying no automatic stay. Then they said automatic stay. They can go back to say no automatic stay and probably do it a lot easier than Parliament can.
I guess the final thing I would add is if Parliament did legislate a remedial scheme, whether it looked like the one that we proposed or something different, it would certainly put the question squarely on the plate of the Supreme Court. There would be no footnote 1 on that piece of charter litigation.
All right, so we'll turn now to discussing the remedial framework that you set out in your article. Could you just take us through what that would look like?
Yeah, so perhaps most importantly, it would exist. There would be one, which I think is proposition number 1 for us. But we sort of, in proposing one, relied on other remedial charter jurisprudence regarding Section 24.1, but also regarding Section 24.2 for exclusion of evidence, following the finding that there was, in fact, a charter violation. So where there was Section 11B violation, i.e. the remaining delay after applying the Jordan framework exceeds the ceiling, the court would determine if the delay is unreasonable, whether a stay ought to follow with reference to the 3 legal interests, as we've articulated them, being the seriousness of the violation, i.e. how far over the ceiling is the case and why is it over the ceiling, how did it affect the applicant or the defendant, which is referred to as demonstrable prejudice to the defendant's interests, and those are threefold in the Section 11B context. There's the defendant's liberty interest, if they're on restricted bail or they're in custody, security of the person. It's been recognized that there's an exquisite agony to awaiting your trial, and that can have serious effects on someone's mental health or their other security of the person interest. And then the final one is fair trial interest, the diminishment of any defense evidence. So the court would look at how did this unreasonable delay affect this particular litigant? And then the third factor would be society's interest in the trial on its merits, which is largely the shorthand for that is how serious is the charge, but there are other factors which might fall under that. In Jordan, the majority recognizes that all society does have an interest that goes the other way towards speedy justice as well. So with reference to those 3 factors, the court would determine whether a stay is appropriate, and you can turn to other 24.1 jurisprudence like the Babos framework for where exactly that benchmark might be. And that benchmark is generally put, a stay is appropriate where a fair trial is no longer possible, or having weighed the seriousness and impact of the violation against society's interest in the trial on its merits, the application judge found that it would be harmful to the integrity of the justice system to proceed to trial. And so one is really, can we still have a fair trial? And the other is it so egregious that it otherwise ought to be stayed anyways? And both of those questions are inextricably tied from this question of alternative remedies, whether there's anything else we can do about it, right? If the trial has taken too long and the person's been in custody, can we mitigate that prejudice by releasing them from custody, awaiting their trial? If in the 3 years that it's taken to get to trial, a defense witness has passed away, can we admit a prior statement that they made for the truth of its contents? And that would ultimately inform whether you can still have a fair trial and whether the breach was such that a stay ought to follow.
So step 1 then, Levi, where you're determining whether the delay is reasonable under Jordan, you guys wouldn't have any issues with the Jordan framework and the timelines?
We say in the paper, and it's commendable progress to have these bright lines. I think it's a benefit for all Canadians to know exactly what the law is, opposed to the vagueness attached to the former regime. But in as much as that might be the case, and again, bearing in mind that we want those to be upper limits, not aspirations. And with what we prescribe by way of this interest balancing remedy, I think that it makes everybody from within and outside the justice system feel a little bit more comfortable about making sure that we're not going to end up with, if not injustice, certainly concerns on the part of the public that the administration of justice isn't necessarily reflecting what they would otherwise have it do by way of the outcomes they like to see.
There may be a risk in the interview to this point that we have come across as critical of the Jordan framework. And at least speaking personally, I'm not. I think that the Jordan framework was the first of 2 steps in the right direction, that it's well crafted, that it's had real benefits to the administration of justice by the way that it's been constructed and by its mere existence. And so we're not critical of the Jordan framework. We see it merely as the first of 2 steps to rectifying what was a very problematic Section 11B system that existed prior to Jordan.
We were perhaps a little bit too optimistic back when we started writing this in the summer of 2016. Because here we sit 5 years later, and the paper took a long time to get published for reasons that were beyond our control. But, if you look at Mills to Rahe to Askoff to Moran, all of that significant 11B litigation took place at the Supreme Court level within about 6 or 7 years. And we just, since Jordan, 5 years later, we haven't really seen a whole lot going on. If Jordan was stage one and the retooling of the remedial aspects of it was to be stage two, we're a long time waiting.
We were worried that we weren't going to get the paper out before it happened.
Well, hey, hopefully your paper is referenced in the decision that finally gets us there. So if we determine under your framework there's a delay under Jordan that's unreasonable, you then go on to the second step where you consider the seriousness of the violation, the prejudice to the defendant's liberty, security of the person, and fair trial, and then you would look at society's interest in trial and in merits as well. Is it equal weight, or would it just depend on case specifics and be treated case by case?
So those three factors mirror the grant test for Section 24.2 exclusion of evidence. And so you can sort of look at the way that test has evolved and the ways in which the various appellate courts have come to grapple with balancing those three interests. And what do you do if two weigh one way and one weighs the other? And my comment would simply be that the goal is nuance and judicial discretion, flexibility to address the case-specific variations in those three interests. And so there's a risk of over-prescribing judicial discretion when really they're ultimately the best situated to conduct that balancing of the three factors. So I don't know if any further prescribed than that.
And choosing those three factors was intentional, and it wasn't simply laziness on our part to rely on Grant as the template for it. I mean, the beauty of this is that there's all sorts of jurisprudential guidance as to how to deploy this type of analysis in these other, 24.2 or 24.1 realms. And that's what makes this such a simple transition. It's an evolution. It's not a fundamental direction change. We're just trying to bring things full circle with the rest of the charter litigation and remedies that are out there.
Yeah, and if you take those three factors and sort of put them in plain language, you're really talking about how serious is the violation, how did the violation affect the defendant, and how would the proposed remedy affect society. When you take it in those broad strokes, you can find those same three factors not only under the Section 24.2 grant test, there's slightly different, more judicious language, but that's also essentially how the framework for whether a stay ought to be granted in other charter contexts is also formulated in the Babos test. There are stand-ins for each of those three factors. How serious is the infringement? How did it affect the defendant? And how would the proposed remedy affect society? It's not, as Andrew says, it's not just three factors that we sort of pulled out of the air, but you can sort of tease those out of charter remedial jurisprudence.
Some might look at your framework and say that this has potential of getting us back to where we were prior to Jordan, where Section 11B without this automatic stay lacks teeth. Do you have any response to that type of argument?
Well, it lacks teeth to whom? I think you have to look at the different justice system participants in place, whether you're discussing whether the weight of a stay, an automatic stay, and I think it's important to note that we're not arguing that a stay ought not to be a possibility, but an automatic stay is necessary to keep state actors motivated, ensuring trials within a reasonable time. I mean, that to me smacks a little bit of pessimism. We ought to have a little bit more faith in our institutions, and reasonable minds may differ on that. There's the obverse question, I think, of whether it's necessary to motivate defendants' counsel. So when you conceptualize it for the state, it's the sort of Damocles, right? It's the ultimate remedy, which will follow if you don't get this trial on in a reasonable time. But for the defense, it's the ultimate carrot. The risk of the windfall, if the case persists a little bit longer than it ought to, then the ultimate remedy, the ultimate potential windfall occurs for the applicant. And so there's another question there that may be a more pessimistic one as to whether it's required as a carrot rather than a stick.
I mean, we suggest some alternative remedies. What we don't talk about is when they would be deployed. I mean, as I'm sitting here, I think to myself, well, maybe in the same way that a stay follows in a lot of this other charter litigation, in the Babos regime, it's in the clearest of cases. Well, maybe it's in the clearest of cases. There's no stay that follows in the face of an 11B breach. I mean, or as I said earlier, there's always that fear of the unknown, and it's compelling, right? I mean, the reality is if it's just one of the myriad of potential remedies, it's still there, and I think it would motivate people the same way. But furthermore, I think it is a little bit too simplistic to suggest that, again, people are motivated by the most drastic of remedies and only that. Nobody wants, somebody's 11B rights to be breached, except perhaps, as the Supreme Court notes, except for the accused, him or herself. But, when I say that, I obviously joking. I mean, at a conceptual and a practical level, nobody wants that to take place. And I think that's motivation enough to ensure that, things move along, in the most expeditious fashion possible.
I know as a prosecutor, it is never in the prosecution's interest to drag things out from an evidentiary standpoint. The reality of the criminal justice system, and it's a good one in a free and democratic society, is the Crown is held to the burden of proof beyond a reasonable doubt. And evidence degenerates over time. Witnesses' memories fade. They become unavailable for various reasons. Video gets erased from security systems, and it really rarely, if ever, adheres to the benefit of the prosecution to have a case take longer than it ought to. And so there, as Andrew says, no one wants to see anyone's charter rights breached, but it's not only sort of that good faith rationale, and there's also evidentiary and pragmatic reasons why our institutions ought to try and ensure speedy justice as well, separate and apart from the individual rights context.
You're not saying automatic or a stay can't result, but that's a potential remedy. So that's enough to get Crown and the state to make sure they're being efficient in their prosecutions. But at the same time, from defense point of view, they have to be efficient and working with the Crown to make sure that the trial is prosecuted efficiently.
And I think that if this remedial framework were adopted, stays might be more common than you would think because, well, first off, we have a history of very assiduously guarding the right to a trial within a reasonable time. But second off, oftentimes, if you look at the remedial jurisprudence about whether a stay ought to follow for other forms of charter violations, sometimes a stay is the remedy of last resort, so the court will consider whether there are any other remedies available. And oftentimes, given the nature of the breach, a new trial is one of those remedies. You can imagine the sorts of situations where that starting the whole thing over might remedy any prejudice that was caused to the applicant. But that's obviously not a possibility. That doesn't remedy unreasonable delay because the new trial would be further down the road. It would cause more delay. So I think that there's a reality that stays might be more common than you might think.
So I'm becoming mindful of your time here. I've kept you guys on longer than I told you I would. But while I have two Crown attorneys sitting with me, I just want to get your sense. You've indicated that Jordan was a positive step in trying to curb some of the complacency in our justice system. As practicing lawyers, do you notice an improvement in getting cases to trial since Jordan?
A lot of that's going to be geographically specific. I'm happy to say that within our office, which is a significant chunk of the Toronto area that's represented here, we didn't have a particularly problematic delay issue pre-Jordan, and it didn't fundamentally change in the wake of it. There are other areas where they may have been experiencing otherwise, and my understanding is that it did serve to motivate things to get moved along. But on balance, I would say that in many respects, and this is a good thing, not a bad thing, I might add. Nothing has changed, and it's good because it's not like we had a big problem before, and it's good because we don't have a problem now. On a more local level, I think the real benefit to be extracted from Jordan is what I would call these bright lines that flow from it. I think everybody just really feels better working under a known cap, albeit, as I said, those particular caps should only be in the extreme. And, we move each case along that comes in our office as expeditiously as possible. And that's the goal. And it's by and large because we have this overriding, public interest in doing that. And, some of it as litigators is entirely selfish, which is that you get the best quality of evidence, present your case, the more proximate it is to the events.
Yeah, I think the ceilings may be more significant depending on the jurisdiction, as Andrew says. If previously you were only getting those summary conviction trials on 24 months after the charge or Superior Court matters 36 months after the charge, then I imagine that those ceilings are quite significant, and the changes which had to be put into effect according with those ceilings, I would assume, are also fairly significant. I think Jordan has had some salutary effects as well, simply by its mere existence. There was an influx of resources to the administration of justice in the wake of Jordan, and in that regard, Jordan has played sort of a discursive or role, I should say, between the judiciary and Canadian society, which has been significant. And then you've also got, there's sort of these constructive incentives, as the court calls them in Jordan, where, if you're not taking all reasonable steps to have the matter proceed as expeditiously as possible, then, you can't come to the court and say that it's a charter violation. There are other sort of incentives within the Jordan framework that have hopefully been significant.
It hasn't made the litigation all that much easier. Part of the upside that was hoped for within the Jordan case was that calculating these things would be much more straightforward. Certainly calculating 18 months or 30 months is pretty straightforward, but what goes into the mix still remains somewhat complicated. You heard me cite that case earlier. It came up with 17 months, 29 and a half days. And, that calculation is, it was an appeal. So I imagine, I haven't read the entire litigation history, but I imagine somebody wasn't happy with the original calculation. And the point is that different judges calculating the same transcripts come up with different outcomes. So that same complexity exists in the litigation, and you do tend to get into the weeds still. I have to say, when I read Jordan, I was hoping that we would not descend into that. And going back to the remedy, that the stakes are so high, the litigation that surrounds the calculation is as intense or more intense at times than the actual factual litigation of the merits of the case.
Okay. Well, the article was certainly really fascinating to read, and I'll be linking it in our show notes. Before I close off here, is there anything about the remedial framework that you wanted me to ask about or that I missed?
I'm really grateful for the expanse of your comprehension of it. I think that based on your questions, you absolutely understood it the way we intended it to be. And as I say, I'm grateful that you were able to do that and make it an easy conversation.
No, well, it was a really enjoyable conversation for me. You guys are really knowledgeable, and I do think it'll be interesting to keep an eye on this automatic stay and see what the Supreme Court of Canada does. It seems like a lot of people think it needs to be revisited, so I'll be keeping an eye out for it, and maybe if that happens, and we can chat again. So thank you again both for joining me.
Okay, thank you. Thank you.